to videotape the whole thing, right? Anyway,
You bet.
so.
I just hit record. So welcome to Next Gen, October 23rd, 2020. My name is Tom Reynolds, president of the Reynolds Group, and I will be your host for the next 45 minutes. Welcome to Next Gen, a peer network founded 20 years ago to support manufacturing, distribution, and technology companies. Our mission is to help business leaders adjust, leverage, and thrive. My background is manufacturing, software development. I use this experience to solve marketing problems and create better sales opportunities for clients, not just leads. My business partner is Hema Day. She manages our SEO to sales department, a highly focused, financially driven, white glove digital marketing program. Helping us today is Linda Feinholz. She is a business growth strategist and a great friend. We welcome questions, so just raise your hands or put something in chat, and feel free to interrupt these speakers because I know they would be very happy with that. The speakers today are Michelle Landis and Rochelle Golden. Michelle is co-founder of Accessible 360 Digital Compliance Consultants, and Rochelle is an attorney at Hatmaker Law Group. And she specializes, one of her areas of specialization is ADA compliance for businesses. The topic today is website accessibility and risk and opportunities. There's been an increase in litigation on website by trolls, and this talk is designed to help you get your website from being low-hanging fruit to at least 1 or 2 branches up the tree. So with that, I'm gonna hit it over to Rochelle. She's gonna start this thing.
Okay, so then I need you to share your screen with me.
You can do that all by yourself.
I can?
Oh, you can, but Rochelle has to stop sharing hers.
Oh, I'm sorry.
Yeah, there.
No, that's okay.
I didn't know I was doing that.
You're fine. You're fine. Share my screen. Here we go. This one. There we go. Can you see it?
Yes.
Fantastic. Okay, so hi everyone. Thank you so much for joining us today. As Tom said, my name is Rochelle Golden and I am an attorney with Hatmaker Law Group here in Fresno. So I'm just gonna kind of get started. I'm really gonna go over the overview of kind of why we find ourselves here. You know, kind of the genesis of why these lawsuits, why communication is important, number one, but number two, kind of why these lawsuits are becoming more and more popular as we know that they're just increasing over time. And so I'm going to just kind of do the legal overview, and then I'm going to pass it off to Michelle, and she's going to do the more nuts and bolts and talk to you guys about what it is that she and her company can do. So while I am a lawyer, I'm not your lawyer yet, unless you need one. You can contact me offline at any time if you've got specific questions. If you're in a lawsuit or you've got something unique to your business that you want to discuss with me, please reserve that for a private conversation. But if you've got a general question, I'd be happy to answer that for you. I want you to get the most benefit out of this presentation as possible. So this is just for educational purposes, and I hope you find it helpful. So I suffered a spinal cord injury when I was a teenager. And so while I don't have communication disorders, I certainly rely on the Americans with Disabilities Act on a day-to-day basis to navigate the world. And so I appreciate what the law set out to do, and it's a very important body of law. And I wouldn't be able to function in the world without it. With that being said, the pendulum, in my opinion, has swung so far in favor of the plaintiff that businesses are just getting hounded. And so my job is to make sure that you have the information you need to make not only your actual physical construction accessible for people with disabilities, but also your websites. I don't do any auditing or anything like that. That's Michelle's bag, but I do the legal aspect of it. And so, and I also do defense litigation and proactive consulting. So that's just a little bit of my background. So we find ourselves here because the Americans with Disabilities Act was enacted in 1990, and it says that no person based on their disability shall be excluded from the goods and services, facilities, privileges, and advantages of any place of public accommodation. So a place of public accommodation is a privately owned business that's open to the public. So we're not talking here about any public entity. That there's ADA requirements that go along with that. But we're going to focus on places of public accommodation. So that's just your run-of-the-mill website, mobile application for your business. And so even though the internet wasn't around in 1990, the Americans with Disabilities Act certainly contemplated effective communication. And so what that looks like is you can't be denied services or segregated in any way or otherwise treated differently because you have a communication disorder, whether that would be a hearing impairment, a visual impairment, cognitive impairment, sometimes all three coupled with a mobility disability. So it's not unusual for somebody to have more than one disability, especially if there's a cognitive disability involved, like cerebral palsy or spina bifida or something like that. And so spina bifida is not cognitive, but it can be coupled with other disabilities. And so so the ADA contemplated providing effective communication. So at the genesis of this body of law, was contemplating like sign language interpreters and closed captioning at that time, audio captioning for those who are blind. And so in TTY systems, which is a telephone system, a relay system between people who have auditory impairments. And so that was really what was contemplated in the beginning. But as the internet and technology has evolved, people are saying, well, wait a minute, we're not relying on really TTY anymore. We're relying on websites and mobile applications in order to access the goods and services that we need. And if I'm blind and your website is not compatible with a WCAG 2.0 AA, now 2.1, which is the the website and content accessibility guidelines. If you're not compatible with that type of coding on the back end of your website, then my screen reader, if I'm blind, will not be able to read the front of the screen, and I will not be able to understand what's on your screen. And so screen reading is definitely not the only technology out there. It's pretty remarkable. There's infrared lights that track people's eyes. I mean, it's unbelievable. But so if you are not coded properly, then somebody that has a disability that relies on assistive technology to access your website, they're prohibited from really understanding what's on your site, or it's incredibly difficult. It can be super confusing, time consuming, and just downright obnoxious if it's not coded properly. And so that's what Michelle does, is she makes sure that the proper coding is on your website. And so as technology has changed, the type of litigation has changed. And so the law says you have to provide effective communication. And so that's, under the Americans with Disabilities Act. So that's always been there. This is not something new. What's really interesting, though, is that there's been a split in jurisdictions across the nation. Normally in California, we're in a very, very, very liberal court system. However, it's been really interesting because a case came down last year. It was Robles versus Domino's Pizza that said, yes, you need to be WCAG 2.0 compliant. They use 2.0 AA, which is the previous version. When the case was started, that was what was in effect at the time. But since that time has, litigation takes forever. So now there's a new 2.1, which is actually, as I understand, more compatible with mobile applications. So when you create a new website, or you're doing an audit or doing some sort of remediation on your website, you're going to want to do it to the 2.1 standard, especially if you've got a mobile application involved. And so if it meets those requirements, then it will be compatible with any sort of assistive technology. And in California, as it sits right now, according to the Ninth Circuit Court of Appeal, you have a website that must be WCAG compliant only if there's a nexus to an actual brick and mortar location. So that's not consistent across the nation. There are other states that say it doesn't matter if you don't have a physical building, you must have a website that's compliant. But here in California, as of today, it could change tomorrow with a new case. But if you find yourself in federal court, then it must have a nexus to a brick and mortar. However, if you find yourself in state courts, there is no nexus requirement. So you've got a split. So what I'm seeing now in my practice is most of my construction related access claims are filed in federal court because they don't want to jump through the procedural hoops of filing in state court. Because we've done a really good job here in California of making it pretty time consuming and expensive for predatory plaintiffs to file lawsuits. So while those cases are brought in federal court, website access claims are actually brought in state court. And so because there's no nexus requirement. The caveat to that is, and I'll talk about that in just a second, is you must be within this jurisdiction in order to bring a state law claim. So just hang that in the back of your mind for just a quick second. So with this latest session, the House of Representatives proposed a new bill, HR 8478, which is the Online Accessibilities Act bill. And it's going to, if it passes, hopefully amend the Federal Americans with Disabilities Act, which is the first amendment to the ADA in many, many years. Most of the federal government has not wanted to touch the ADA, but this is an opportunity for, and it's actually a bipartisan bill, so fingers crossed that it will pass. But what it does is it says, yes, no individual shall be segregated or be denied participation for a consumer-facing website or mobile application. And it establishes actually WCAG 2.0 A or AA as the current standard for compliance. Now, there's been pushback on that because of the 2.1 standard that's come out that's more compatible with mobile applications. But the good news is if you do comply with 2.0 and this bill passes, then you're presumed to be accessible. So that's good. They're not using the highest standard, but it may evolve over time. And so a private entity, though, can provide alternative equivalent facilitation of the content of your website or mobile application. So if you're a small business and you can't afford to build a WCAG compliant website, then there is a carve out for that. However, it's going to be up to that business to litigate saying, okay, we couldn't comply with WCAG, but we did this instead. Maybe we did some sort of online meeting or some sort of virtual shopping or whatever. And that's sufficient. Well, the plaintiff then and you are left with battling it out in court as to whether that was truly sufficient for that person's disability or not. So it's kind of a blessing and a curse at the same time. And so the procedural requirements of this bill are really interesting. So it's mandating that within 180 days of enactment that the United States Access Board goes through their proposed rulemaking process. So they're going to draft guidelines and regulations and go through the public comment period and all of that. But then within a year, they must have issued final regulations. So it's a pretty tight turnaround time, which is unusual, especially for federal government. So it's a pretty aggressive bill as far as the administrative burden goes, because it also mandates that the Department of Justice establish a procedure for investigating complaints. And so with that being said, since the DOJ is going to be involved, in order for a private lawsuit to be initiated, that person has to exhaust their administrative remedy. So, and what that looks like is before they can file any lawsuit, they have to give a letter to the owner or operator saying a very detailed letter, here's what I experienced, here's my disability, this is how it impacted me, please fix it. And then that person, that business has 90 days to cure. And then if there is no cure within that 90 days, then the person has to file with the Department of Justice. And then the Attorney General has 180 days to investigate that particular complaint. If they don't investigate it within that 180 days, then it expires, and then the person can then initiate a private lawsuit. If the Attorney General's office does pursue a claim, then the private person is barred from filing a private lawsuit. So that's great, but my experience with working with federal and state agencies for like Fair Employment Housing or DFEH or the Department of Fair Employment Housing, or FEHA, Fair Housing Act or the EEOC, a lot of the time lapse or the time that they had to investigate just lapses. And more often than not, that state agency or that federal agency will have an immediate right to sue process, like we do here in California with the Department of Fair Employment Housing. So I presume that's probably what's going to happen with the Department of Justice, that there's going to be some sort of shortcut because they're not going to be able to handle that type of volume of complaints that I presume would be coming in. But what's kind of shocking is that if the Attorney General does pick up the case and it's found to be not compliant, and to have provided discrimination, a pattern and practice of discrimination against persons with disabilities, the penalties are very steep. It's for your first penalty, it's $20,000 maximum, can be less than that, but up to 20,000. And then if it happens again, or they find a second issue, it can be up to $50,000 maximum. So that's really, that's a pretty steep penalty. So you don't really want the Department of Justice banging on your door. So if, let's say, that the AG's office does not investigate, then within that private cause of action, that private complaint, there's a heightened pleading requirement. So normally in federal court, you only have to just give a plain, short, concise statement of the claim, unless you're dealing with some sort of fraud, which requires a heightened pleading requirement, meaning you have to be very specific about how you plead the complaint, or else it will get dismissed. Well, that same heightened pleading requirement would be applicable to the Online Accessibilities Act. So you would have to plead not just, I have a disability and here's the barriers. It's, I have a disability, this is the barrier that I encountered, this is how it affected me when I was using your website, and this is the damage that it caused. So it's very detailed and specific. And if they can't get there, then the defense lawyer on the other side would obviously attack that by a motion and try to get the complaint dismissed. So, so that's good news, because in my experience, plaintiffs like to just use canned complaints. Plaintiffs' law firms will just use the same complaint over and over and over again with just switching out the names. And so that's not going to cut it under this if it passes. So that's good news. And again, it amends the Americans with Disabilities Act, so it only allows for injunctive relief. So under the federal law, a person can only sue you to fix something. They cannot sue you for any sort of monetary damage, unless there was a physical injury or something like that involved. But if you're just suing as like a construction related access claim or a website access claim, it would only be for injunctive relief, only to make that owner operator fix the website. But the caveat is that in California, we have what's called the Civil Rights Unruh Act, which was enacted in 1968, and it was modeled after the Civil Rights Act of 1964. And so we've actually been on the kind of the breaking edge here in California way before the federal government caught up. And it says that all persons within this jurisdiction. So and some of you might have been subject to one of these lawsuits, but there is a high frequency litigant outside of Arizona, and she will say, I couldn't access your website. It didn't sufficiently describe the accessible features, let's say at like a hotel. And so I decided not to stay there. Well, she accesses those websites in Arizona. So her state law claims are not, they can't go forward because she's not a person within this jurisdiction. The injury didn't happen when she was in California, she was in Arizona. So that's the caveat with filing in state court, or even putting an Unruh Act claim with your Americans with Disabilities Act claim and filing in federal court, because you can do that as well. And the Unruh Act says basically the same thing as the ADA, is that anybody with a disability, but it takes it one step further. It's disability, medical condition, or genetic information, that they're allowed to have equal access to everything that a person that's not disabled has. So it's very, very similar to the ADA, but under the Unruh Act, this is where the money comes in. And so it's $4,000 per occurrence, and that's been interpreted to mean per visit. So you can see how easy it would be for somebody to sit in the comfort of their living room and go to your website 5 or 6 times and then say, okay, I was damaged, so now I want $20,000 because I went to your website 5 times. And by the way, I want my attorney's fees, and I want, you're going to have to pay for your attorney. So it becomes very expensive really quickly if you find yourself subject to litigation. So the best thing that you can do is to take Michelle's advice and look at her company, and really, and Tom as well. Really get the right group of people on your team so that you can proactively comply with the Americans with Disabilities Act and that new Online Accessibility Act if it actually passes. So that is all that I'm going to be talking about today. If you've got specific questions that you want to ask me, feel free, but I'm going to pass it off to Michelle because I know what she's got going on is super fun and interesting. So Michelle, take it away.
Thanks so much. I am going to be bouncing back a little bit from screen to screen. Before I launch in, I want to just pick up on a couple of things that Rochelle went through. Number one, the WCAG guidelines. I'll talk about the Web Content Accessibility Guidelines as issued by the W3C in just a minute. But Rochelle's absolutely right. The 2.1 version, which actually came out 2 years ago, so it came out 2 summers ago, is geared towards responsive web design. Here's a little bit of insight. 2.2 was supposed to come out in November, but we just got a 6-month reprieve. So the seed that I want to plant is, number one, this is not a fad. It's not going away. The W3C and the rest of the world is already moving on to another set of standards, which will be in effect in 6 months, apparently. And so we'll use those as a global accessibility company. It doesn't matter which country or which business vertical we're auditing in, we're using the current standards. But I'll talk you through the best way to kind of step yourself through. I don't like to light people's hair on fire, because when you get a demand letter or a lawsuit, it feels, really shocking anyway. And so we'll talk about some strategies to put in place to mitigate that risk. Number two, the cookie cutter claims, right? Like Rochelle said, they're very generic claims. I've seen things like one college or university in the title, but somebody else is the past college or university they just sued website in the thing. They're going so fast, the marketing departments at the high volume plaintiff attorneys, that they're kind of careless sometimes. The history of those claims, especially in the federal court system, going back to the days of Carlson Lynch being one of the first high volume ones out of Pennsylvania, they used to include a scanning tool report, and it would be like a SaaS product, a software as a service product that would run, scan your website and run through. It was really easy for us when we started attacking this as a group to help companies defend themselves on this and make their websites and apps accessible, to pick apart those scanning tools. So I will touch on scanning tools as well. And then I think that is, pretty much it for the transition part of it. I'm going to go ahead and share my screen as well. And I think what I'll do, if it's okay with everybody, is I might leave mine in slide mode here so I can jump and forth through the slides, but hopefully it is large enough, Tom, for the recording. And so you can see my screen, right, with the slide up?
Yeah.
Just to confirm? Okay, perfect. So let me jump in. This movement that Rochelle's been talking about, right? The ADA, we've done a really good job in our country about physical ADA space. This conversion is about moving us to compliance with inside of our visual environments, right? Everything is online.
Michelle, we're seeing the agenda. Is that what you want to see?
No, that's not what I wanted to do. Hold on. There you go. So you can see, Can you see the slide deck now?
Yes.
Perfect. Okay, that's what I wanted you to see. So the point I was trying to make was the high volume plaintiff attorneys did the same thing back in the early 1990s with the physical space. There was a lot of high volume plaintiff law firms going after buildings and things like that. It doesn't take away from the validity of the cases, but it's a highly litigious area for businesses, right? The same 4 disabilities that are covered in the ADA are the same 4 that we use in our auditing services. And I should just pause maybe and circle back. I jumped in real quickly without probably a real proper introduction to Accessible 360. What we do is live user auditing. We're the nation's leading live user auditing company. We've been at this as a team together for over 5 years, and we're over 40 employees now. We're located in Minneapolis, Minnesota. We've had the privilege of working with the Reynolds Group on sites. I've actually met both Tom and Rochelle in person, having been out there a year and a half ago or so to speak at a couple of events. And it's just a pleasure to join the team again and kind of level set with what's been updated. I will talk about other methods, and I'll talk about overlay tools in a little bit too. And I plant those seeds so that if I forget, one of the audience members can help me remember to talk about that. I do want everyone on the call or who watches this video later to understand we're not talking about just a few people. We're talking about a very large group of people. In fact, in the United States, it's estimated that 61 million of us have a disability. And if you pause and think about it for a minute, if we're lucky enough to continue to age, we're all going to develop one. We've never had a situation with humans where they're dependent on technology and then they age. So this is for people who have a current disability, but it's also for everyone who's going to develop one as we age. And so it's really important, I think, to make sure that we're paying attention to that, right? There's a huge spending power. As Rochelle said, this is about everybody getting access to goods and services online. A couple of other slides in here I can touch base real quickly on the highlights of the business case for accessibility. There is a cost associated with it, especially if you have to go back and remediate a site or a mobile app that you've already built. So I'll really push the concept of thinking about building accessibility in. Those are the types of things we've done with the Reynolds Group, and they're much more affordable. It reduces risk, but also please keep in mind, the more people that can use your website and apps, the more income for your business. So don't look at it as a business compliance issue only. Look at it as an opportunity to welcome more people into the audience. Rochelle mentioned assistive technologies earlier. These are a couple of examples on the screen. JAWS and NVDA are the two most common desktop screen reader software. You would download these onto your computer if you have a vision disability significant enough to have some lift and some benefit from using these. JAWS you pay for, NVDA is free. NVDA is really gaining in market share in the past couple of years, but JAWS, typically people are totally blind, have multiple ways of obtaining that subscription, but it can be about $1,500 to $2,500 for that software. These two icons are for screen readers in mobile. On Apple or iOS systems, it is VoiceOver, and on the Android system, it's called TalkBack. And then these are different mouse options, right? I'm moving my mouse around the screen, but this is a iRetinal mouse. Rochelle mentioned a little bit about that, about imagine going through. You might see these on persons' wheelchairs who have spinal cord injury or paralysis, and they're using their eye movement in order to simulate keystrokes. Fascinating what they can do and how fast they can move with that. And this is an example of a kind of a typical switch. This gentleman, Aaron Cannon, is my Chief Accessibility Officer at A360. He was also a co-founder. Aaron is the individual who has done the majority of our expert witness testimony. So listening to Rochelle talk about, the litigation part of this, to put it into context, I would tell you, after working with thousands of clients, is that most of the demand letters and most of the lawsuits are litigated, right? With the help of attorneys, in 2 weeks to 2 months, right? That's kind of a range that I throw out there, and I'm happy to be contradictory, Rochelle, but you let me know. But there are some of them that move forward. She mentioned the Domino's case. That's probably the biggest one, in our industry. It's been going on a while. It is public record by way of documents that A360 has been hired to support them in the appeal. They had been working with a different vendor before, but that change is out there. So mentioning that case, I just want to make sure that everyone knows that is some of the work that we're working on. But last summer in California, we defended Omni Hotels International. And this one was really important. And I talk about it not to talk about A360, but to talk about the legal trend. They had a very difficult element in their system, and hotels, lots of hospitality companies, but even spas, massage therapists, nail salons, now they're using these automatic calendar features or widgets or plugins. And the calendar can be very difficult to make fully accessible. That was the case with Omni. We were able to help them get that fully accessible, and then we successfully helped defend them in court. For the record, we do not work for the plaintiffs. We will not work for plaintiff attorneys. We're not a part of that racket, is my own personal word there I'll throw out. We work on behalf of clients and getting them accessible, and also defending them in court if it's needed. Let me talk about the W3C real quick. The W3C is the World Wide Web Consortium. This is the organization that launched the Web Content Accessibility Guidelines over 21 years ago now. You'll notice that it said web content. The reason it said web content is because we didn't have apps when it was launched, right? When it was issued. Just like the ADA talks about places of public accommodations, nobody, I think, can argue that the internet, the World Wide Web, is not public. But of course, it didn't exist in 1990 when the Americans with Disabilities Act was passed into law. And so as we progress quickly in technology, it goes without saying, I think, that sometimes government and some of the laws take some time to catch up. Let me talk about the different guidelines out there. So this is all clear. I find that a lot of people sometimes say, oh, it's gray, or I really don't understand, or what's the difference is. Let me just walk you through this real quickly. And I'm going to go back up to the laws for just a moment to level set. The Americans with Disabilities Act of 1990 does not have an amendment yet, as Rochelle explained, to cover digital environments. But there is a law in the United States that does, and it's called the Rehabilitation Act of 1973, and it gets no street cred. No one ever talks about this law. So I'm going to touch base on it real quick. It had two amendments that were passed in 1998. And this is where the term Section 508 comes from, and then the lesser known, of course, 504. And these just mean simply, and Rochelle, please jump in if you want to, but Section 508 required federal agencies to make their electronic and information technology, EIT, an acronym we don't even really use anymore, accessible to people with disabilities. So Section 508 is government. Section 504, you can remember easily, in that if your organization receives funding for your programs from the federal government, like healthcare and public education, then you would be considered required to make your digital environments accessible because of Section 504 compliance. What's really important to understand is that until very recently, January of 2017, Section 508 had these really old compliance requirements that were written in 1998. So our work as auditors meant that we were trying to match current websites and current mobile apps to these really old standards. And to be quite honest with you, we had gone with the WCAG 2.0 level AA right from the beginning, but it was a struggle to kind of get to match those old things because they were out of sync. What was wonderful is they made a 1-year notice, which they're required to do. And then on January 2018, the Web Content Accessibility Guidelines version 2.0 level AA became in effect for Section 508 and Section 504. So if you are a government, healthcare, or public education entity, you are fine based on the federal law, right, Rochelle, in going for a letter of conformance to WCAG 2.0.
Yes, that's right.
Yeah. And as she said earlier, WCAG 2.1 came out and it builds on 2.0. So of course, everything in 2.0 is in 2.1, 3 brand new guidelines, 17 total tests. So let's talk about A, AA, and AAA. They're not different versions. The version number is 2.0 or 2.1, but the level is A, AA, or AAA. It's very well established in our business practices. And again, not even in the United States, but Canada, the UK, EU, Australia clients, everybody. Level AA is the standard you should be reaching. And here's the simplification. A is not enough. AAA is too hard. So right in the middle, AA is the one that you want to go for. If you have new input modalities on your responsive web design sites and some of the other, and some web applications that are rendered mobily, then maybe these 12 additional tests could be reached. What I've noticed a good year and a half ago, shortly after these came out, so maybe even longer now, the plaintiff attorneys would request that you meet WCAG 2.1 level AA, but almost every single, I'm only aware of 2, where clients agreed to meet 2.1, and those are pretty recently this year, but you typically get it negotiated down to WCAG 2.0 level AA. And so that's kind of the, report from the front, if you will, out there. If any of you are web developers and read some of these, you can, you know that the basis is divided into 4 different principles, right? Everything must be perceivable, operable, understandable, and also robust by their definition in the WCAG guidelines. One thing that I will point out that builds on the Unruh Civil Rights Act and a lot of the other detailed legal things that Rochelle pointed out is the California Consumer Protection Act does have requirements in it for WCAG 2.1 in 2021. This is all about your cookies, right? All about your cookie notifications. And so being that there's this additional requirement in there, it's bringing, additional pressure from other areas as well. So I am going, this is my pause for like the good, bad, and ugly. I can tell lots of stories about this, but what I wanted to do was go ahead and share with you a JAWS demo, because if you've never listened to a screen reader, this is a pretty powerful example, it's Erin Cannon. I'm going to pick on the Cheesecake Factory. Hope nobody works for them or is an attorney for them, but it just is what it is. And this was done a while ago, so it's not a statement of what their condition is now. I'm going to stop it at some point through it. I will not play the whole thing. And then incidentally, as a teaser, I will tell you this. I do have another video I'm going to play a little bit later towards the end of the presentation, which is geared to do a little bit training on some of the best fundamental things that you can do on websites. And so we'll have an opportunity to watch a couple, but I'm going to let this roll here now.
All right, so here we are at the Cheesecake Factory. Just said, welcome to the Cheesecake Factory. Let me slow down my screen reader so you can have an easier time understanding it.
Slower.
All right, that should be better.
Welcome to the Cheesecake Factory.
Welcome to the Cheesecake Factory.
List of 5 items. Visited link, menu.
So we've got a list of 5 items, and we've got a link, which is menu.
Visited link, locations.
A link of locations.
Link, gift cards.
Gift cards.
Link, careers.
Careers.
Link,
more.
List end, blank.
All right, that's the end of the list. And then if we keep going down.
Visited heading level 1, link the Cheesecake Factory.
The next thing I hear is a heading level 1, and it says the Cheesecake Factory, and also tells me that that's a link.
Heading level 2, more than 250 dishes clickable.
More than 250 dishes.
Link, buy a gift card.
Buy a gift card. That doesn't really.
Heading level 2, visit US today clickable. Heading level 3, view hours, get directions and download menu clickable.
So it's kind of doing something a little bit unexpected. As I just up and down arrow key through that text.
List of 5 items.
And then, and now it totally threw me out of my location. I just lost my spot. But as I was arrowing up and down on that text, I could tell that that text was changing, but I wasn't really being told that that text was animating. So that's a pretty big problem for screen reader users. Anytime you have a carousel on your web page, you need to pay special attention to it to make sure that it's accessible, and that doesn't appear to have been done in this case.
Nope.
And so that can be pretty confusing, where you have content that sort of animates and updates on the fly without notifying screen reader users.
The Cheesecake Factory, heading left, blank. Link, visit veriandovid.com. Link, salted caramel cheesecake. List of 5 items. Link, Facebook. Link, Twitter.
And we got Facebook, Twitter, so
link,
we've got their
Pinterest.
Social media icons.
Link, it's link, newsletter, list end. List of 5 items. Link, contact US vertical bar.
We have another list.
Link, investors vertical bar.
So the page is pretty well structured. They have their lists of things, and those are in lists. So that's good. One thing to note is that screen readers really, when I look at a page with a screen reader, it's a very one-dimensional view. So I start at the beginning of the document and I go down and through and to the end. And there's not really a concept of something being beside something else. If you have some text and there's an image next to it, that's not really something you can communicate to a screen reader user.
So I'm going to pause there for just a minute. Hopefully you got a chance to kind of get a feeling for that screen reader. Aaron and a lot of our blind auditors listen to their screen reader software at over 500 words per minute. I'll note that Aaron has been blind since birth. We joke that he can probably code in more languages than millennials will ever be taught now. But he is a software programmer. He became one. He worked at an agency for years, and he's been working in digital accessibility since 2007. And so the methods of website accessibility testing are kind of the one thing I want to talk about. When you look at this business compliance, kind of problem, right, or opportunity with businesses, you're dealing with cybersecurity, you're dealing with privacy issues, and of course, now we're talking about accessibility. The method for scanning a website for a security breach makes technological sense. And the reason it does is the threat in security is a bot. And so it makes absolute sense to write a bot to find a bot. Privacy is also something that you can manage or govern through some SaaS products. But the accessibility of those privacy statements is what I was talking about up here with the new requirements with the California Consumer Protection Act. They're going to require that those cookie notifications are in fact 100% compliant and usable for both screen reader users and for keyboard only navigators and anybody else. And so it's really important to understand the proper method for testing for accessibility. So I want to talk about 3 concepts here. I want to talk about overlay tools. I want to talk about scanning or SAS, and I want to talk about the concept of a separate but so-called equal website. Let's talk about overlay tools for a minute. There's a huge buzz out there by my fellow subject matter experts in digital accessibility auditing, and the thought, or kind of the laughable thought, that companies can use an overlay tool in order to fix accessibility. An overlay tool is a widget or plugin, something that you download onto your website, which I hope your ears are picking up, because once you download something to your website, you could also potentially be risking issues in your own security. But these overlay tools will, here's the pitch. We'll fix your $4,000, $40,000, $400,000 digital product in 48 hours for $49. I am stunned at the number of companies, which I think are credible companies like ADP, who fell for that. ADP is the subject of a lawsuit now. And again, this is all just my personal opinion about it, but they were sued because they use a tool called AudioEye. And they were found to be not accessible. These overlay tools can do a couple of things. Number one, if not installed properly, well, even when installed properly, they can wreak havoc with the assistive technologies that people already know how to use. And so the important thing to really level set about assistive technology is that if someone has a disability which precludes them from accessing a website or mobile app in the way that I assume the rest of you do on the call, I know I do, and they need a piece of assistive technology, they would never get to the website or be able to use the app unless they were already using their own assistive technology that they know how to use and that works for them. So the thought that you would put a screen reader on a website in case a blind person lands on the website and they want to use it is ridiculous, because they'd never get there unless they were using their own assistive technology. So be wary of the overlay tools. Every single time we have audited them, and it has been in some cases, some are public, some are private, some have just been, can you tell me what this is doing? Certain things, like one quick example is an overlay tool was on a website where the retailer sold cribs and car seats. And there was one page on the website about registering your product. And what's really important to parents, new parents or existing parents, is if you have a car seat and you register that product, that's the mechanism for you to get notified of recalls. When you can't, Aaron, for example, a father of 5, if he couldn't register the latest car seat for the new baby and he never got recall notices, that's a pretty big issue, right, Rochelle? And so we need to make sure that the overlay tools don't interfere with the content and functionality of the websites. And what I'm here to tell you today is I have never seen them worked as sold, and they are still a very controversial topic. And there is a tremendous amount that you can read out there, including from Lainey Feingold, who is not a high volume plaintiff attorney, but definitely an advocacy type one on the plaintiff side. And she has a lot to say about the overlay tools as well. So I'm going to leave those there for now and pick up in Q&A if you guys have anything. We are actually, I was planning on an hour, Tom, and I am running out of moments because I just glanced up at the clock and we're at our 45 minutes. I assume that we can continue to record this and it will just be a little bit longer. Is that okay? And I'll try and wrap up. You're on mute, so I can see you talking at me, but I can't hear you.
Very true.
Okay.
What I'd like to do is see if there's any questions, and then if people need to beg out, they can, but then you can continue on. Is that okay?
Yeah, that sounds perfect. Happy to take any questions.
Great. So for anybody have a question? Not yet. Can't hear you either, Linda. So
yeah, she's muted too.
At the moment, there are no questions in chat. Does anybody want to unmute themselves and pose a question?
All right, we can keep rolling.
Okay, we'll keep rolling then. So let's talk about the SAS tools. SAS tools are scanning tools, right? I talk about this independent study from the UK often. I like using this because it's not A360 saying this. By the way, we at A360, we have a scanning tool too. Everybody has a scanning tool. But what is the difference between some companies is not everyone's honest about the limitations of scanning tools. All scanning tools, I don't care whose it is, some are better than others, but you can never test for everything in the WCAG guideline success criteria with a piece of SaaS, with a software as a service tool. You can get some low hanging fruit, but at best you're covering about 25, maybe 30%. The big thing to also understand is they can return a lot of false positives. So when we're consulting with companies, what we say is just this, and I'm not trying to do a sales pitch, but I'm just trying to get you to think about the process a little bit differently. If you can get a live user audit done first, fix the website or mobile app with expert help, and then maintain it, this is the area where we feel that SaaS tools are better utilized because the developers know more about the limitations of them, and they're not wasting time, and energy, money, or resources fixing things that don't need to be fixed. And so holistically, it's a better approach in our opinion. The last thing I want to talk about here is separate but so-called equal websites. Any attorneys on the call, like Rochelle or anybody that watches it later, if you used Barbary, the digital study guide from Thomson Reuters, spinoff of that company anyway, to study for the bar exam in your state, that was the subject of a case that we were involved in, and this is public information, so I can talk about it. They had a so-called separate but equal website on there from usable.net. When we live user audited it, we found it not to work as thought by the other vendors and the client. And there's also a couple of other cases. One, the Scandinavian Airlines one, where the judge ruled against using this so-called separate but equal site. This is a concept, real simply in layman's terms, that they create a separate but equal site. Now, I'm going to refer back to the Americans with Disabilities Act. And years ago, when I was teaching continuing legal ed with attorneys, I'd have a slide that had a picture of a hallway, say from the 50s or earlier, and it had two different drinking fountains. And the thought I just want to leave everybody with is there is absolutely no technical, and in my opinion, no business reason you should ever consider putting one group of people through one digital door and another group of people based on a disability through a different digital door. It is absolutely unnecessary, and I think it's an incredibly bad PR move. There's no reason to do that. Set aside the fact that they, the ones that we've audited haven't worked that way. There's absolutely no reason to do it. So what you should do is fix the website to make it accessible. I'm not going to talk about our processes, but I am going to talk about general practices about becoming digital accessibility. And one of the key takeaways as advertised in this is what are some things that you can do? Like, how do you do this? And I'm going to go through a couple slides, and then I'm going to play another short video, and then that should wrap it up for us. And I'm happy to stay on for extra questions and stuff too. So number one rule of website accessibility, semantic HTML. A lot of developers don't do HTML because it's markup, and they don't consider it real development work. I can't stress enough how important this is to start with a good foundational HTML markup. And some of these concepts will be demonstrated in this short video coming up. Rule number two of website accessibility, label, 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 label. You've got a link, label it. You have a button, label it. You've got a form field, label it. Understand what you saw in the JAWS video, that it's not obvious to everybody, especially if you're blind or have other types of vision disabilities, that what things are. So label them. ARIA, accessible rich internet applications. One of the telltale signs that a developer or an internal team or somebody has gone about attempting to fix accessibility the incorrect way is if I pull it up and run an automated test and I see how many incidences of ARIA are out there. From Aaron Cannon, my co-founder and chief accessibility officer, I will tell you to remember this. ARIA is like salt. Every recipe needs a certain amount, but if you put too much in your dish, even your dog won't eat it. And ARIA can wreak havoc with screen reader users. This is a scenario of kind of accessibility in practice versus accessibility in theory. And the practice is you should always try to solve with semantic HTML. This should only be used sparingly because it does override and it can have wreak havoc again with assistive technology users. Design for keyboard only users, designers and UX people out there. Think about your app and your website. does the flow make sense? If you were to put your mouse away and try and buy a pair of jeans, can you pick a color and a type of wash and check out? Are you able to do on the website with your keyboard only navigation what somebody could do with a mouse? This next one is about drop-down menus and navigation. A couple quick tips here. Site navigation must work for both keyboard only and screen reader software users. Avoid forcing keyboard users to tab through submenus. And use ARIA to indicate open and close status. That is one good use of ARIA. So menu expanded, menu closed, modal open, modal closed. Lastly, accessible sliders. That's what the video about the Cheesecake Factory was about. In a nutshell, you've got to understand that a screen reader is going to listen to that website. And if you have something that plays constantly or animates like he was showing us, they'll leave the website. You're just basically like sounding super loud music at in someone's face if they came to your door. So really be careful with sliders. I'm going to close this then, Tom, and I'm going to go back out to a little gift, if you will. I'm going to play the first section of some basics in web development guidelines video, and I'll stop it, I think in about 8 minutes through. So we'll just let this record. And when I stop, we can even do a closing, but I just wanted to thank you for inviting me, Rochelle. It's always a pleasure to speak with you. Thanks for your great legal advice in the beginning of it. And again, this is Michelle Landis with A360, and I'll go ahead and play this as a treat for all of you.
This video is for web developers who are charged with building web pages, templates, managing content, anything to do with changes to the actual HTML, CSS, or JavaScript within a website. If I could only do one thing to improve the accessibility of the web, it would be to have everybody start using semantic HTML. I think that one thing would do more for web accessibility than any other thing that we could possibly do. So what do I mean by semantic HTML? Well, quite simply, if you have a header.
Shoot, I think we lost internet. Hold on.
Mark it up as a heading. If you have a list, mark it up as a list. If you need a button or link, don't use a div or a span, just use a button or a link. This might seem simple on its face, and yeah, it is not too difficult, but it does require some thought. For example, just because you have some text and it's centered and large fonts and it's bold, that doesn't necessarily make it a heading. Now, it very well may be a heading, but it...
Oh, I apologize. I think I'm going to play it just from here, see if that works.
And if it won't play, if you could include the link in the chat, that would be great. So people would be able to play it on their own.
Yeah, I wish it could. It's proprietary information only available in our hub, so I can't supply a link to it.
Okay.
Yeah, sorry. But I can splice it in though, Tom, at the end when you make yours. I wonder, I must just have a college student or two jumping on mine. I'm not really sure what happened. Sorry about that. Let me just see if I can reload it real quick, and hopefully with some splicing.
This video is for web developers who are charged with building web pages, templates.
Let me get you there.
Large fonts and it's bold. That doesn't necessarily make it a heading. Now, it very well may be a heading, but its appearance is not what makes it a heading. It's how it's being used that makes it a heading. Likewise, just because you have some content stacked vertically, that doesn't necessarily mean it's a list. Or maybe you have some content that's horizontal. That doesn't necessarily mean that it's not a list. It's important to look past the styling and consider what is the actual semantic meaning of your content. And how does it relate to the other content on your page? And then do your best to express those relationships and structure in your HTML. The reason this is so important is because screen readers really do pay attention to this stuff. If something's marked up as a paragraph, the screen reader is going to treat it in a very particular way. If it's marked up as a table, it's going to get a different type of treatment, and so forth. Now, not all markup is going to affect screen reader users. For example, a screen reader is mostly going to ignore divs, emphasis tags, spans, and other things. But the more semantic information you can provide in your markup, the better the experience is going to be for screen reader users. Some examples of HTML that's used with poor semantics are, for example, using a BR tag to make space between paragraphs, or using an H1 to create large bold text. An LI element doesn't mean stack text vertically. In each of these cases, the HTML has strict meanings, like line break, heading level 1, and list item. Make sure that the HTML tag on every page includes a lang attribute. Screen readers, when they first load a page, they're going to look for that language declaration. So if a screen reader user who runs a Spanish speech synthesizer by default, but they go to a page that lacks a language declaration, then the screen reader is going to start trying to read the English content as though it's written in Spanish. So it's going to start rolling the R's and pronouncing the vowels in non-English ways. So it's very important to ensure that you have a lang attribute on the HTML and that it's set properly. Also, make sure that every website page on your site, or view if it's a single page application, has a unique title. Home pages can have just the name of the site or the brand as the title, although you could add home to them if you wanted to. But all inner pages need to have titles that are specific to that particular page. Screen reader users hear these titles as soon as a page loads, and it also helps them to distinguish between different tabs when they have multiple tabs open on a single site. If those pages have different titles, it makes it a lot easier to know what page is what. Now, if you do want to put your site name or your brand in your title on every page, that's totally fine. You can do that as well. It's generally best to put the brand at the end of the title and put the content that distinguishes or titles this particular page at the beginning. That way, the screen reader user is going to hear the page-specific information first. This is also a good idea for SEO. So for example, if you have a page that you want to rank well for chicken recipes, the search engines, like human users, will appreciate having the word chicken recipes right at the beginning of the chicken recipes page title.
For keyboard-only users, the skip navigation or skip to main content link is very useful. Anytime a site has more than a handful of header links or any situation where a keyboard user needs to hit tab, 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 tab to get down to the other content on the page, the skip to content link will save them a lot of time by giving them the means to jump over the header. The link should be the first tab stop out of the browser address bar, and it doesn't have to be visible all of the time, but it does need to be visible and in a logical space near the top of the page when focused, as you can see in this example from our website. Skip links work best when they target a focusable element like another link or control, or you simply want to get the user as close to the main page content as possible. A couple of good options are the last link in the website navigation, the site search button, or the last active link at the breadcrumbs. But make sure the behavior is consistent across the entire site. We want users to be able to predict that they'll end up in the same spot on every page, and consistency is always good. Lastly, avoid the urge to create other cool skip links like skip to navigation or skip to footer, as these won't be used by many users. As Aaron mentioned, screen readers interpret text in one dimension, forward and backward. In doing so, they interpret each HTML element they find and do their best to find meaning and order in the code. Ideally, the HTML semantics are enough to convey all of the meaning necessary to help users understand what's going on. There are situations where the HTML meaning is not enough, and extra text can be added to describe non-standard behavior or complex website interactions. For example, a carousel or slider might be perceived by a screen reader as simply a list of images with some links and no context. By adding a sentence or two of screen reader only text or text on the page that is not visible but still exists for interpretation by the screen reader, we can provide extra information and labels for any unexpected content. Here's an example of a screen reader only text CSS class. Well, it is also possible to simply position screen reader only or SR only, as in this example, off the screen, say -500 pixels to the left. We prefer this more contemporary method of packing the screen reader text into a tiny invisible space and then clipping it out, or only showing the page content that is outside the area containing the screen reader only text.
One thing that sighted folks often take for granted is finding the content you're interested in on the web page. For example, imagine that all the content on a web page looked exactly the same. There's no font or other styling differences, no boxes around various parts of the content, no dividers, no paragraphs or even line breaks. Just one big block of links and text. How would you figure out where the main content started? How would you find the sidebar? How would you even know there was a sidebar? When a page lacks headings and landmarks, this is pretty much how screen reader users experience it. Now, if you're using HTML5 correctly, your site should already have landmarks by default. So when you wrap your navigation section in a nav tag, or you wrap your main content in a main tag, your header in a header, and your sidebars in a side tag, then screen reader users are automatically told what part of the page they're on. But not only that, they also have, when you use that markup, to jump exactly to the section that they're interested in. So they can jump right to the main content. They can very easily jump to the sidebar or whatever else they're interested in. Headings are the other ways that screen.
So I thought I'd stop there, Tom. That's a really, I wanted to get through the part where he talked about things are in front of and behind. There's no concept in accessibility about next to or on top of or underneath. It's just all linear. And I think, you know, those quick highlights and different things about some of the basics should give everybody a really good, I think, foundational setup. And I will say I'm happy to take questions, but I am not a developer, but toss anything you want at me if you want to.
All right, are there any, go ahead, Linda.
So this is Linda. And I just want to say I really appreciate those two videos because they were really good ways of forcing those of us who are sighted to hate the experience we were having and start to understand the unexperience that an unsighted user might be having.
Yeah, thank you for saying that. It really does. And, you know, we don't like to, you know, say, and this is kind of controversial too. It's like, oh, well, throw a blindfold on and you can see what it's like, you know, to be blind. Well, first of all, no, you can't, you know, put a blindfold on and see what it's like to be blind. But you, so we do some simulation or immersion trainings when we do big corporate trainings, and they do include some glasses that simulate some vision disabilities, but it's meant to get you into that uncomfortable space, like you said, Linda, because that's where learning happens. That's where adaptation happens. That's where innovation happens. If you're not aware of the pain that somebody else is feeling, and this is not related to just digital accessibility, we could look at what's going on in our country and see, if you don't understand what it's like and what these people, human beings, are going through, then, you know, the case doesn't really hit with you. But as soon as you do, then it really hits home. So very important comment. Thank you very much.
Yeah, I think, and Tom, you can reinforce this. A lot of us who have spent time in internet land are aware of things like hot, what do you call them? Hot readers, whatever, that will see where the eyeball goes of a sighted person on a page, and they will mark out where we spend time. So then we go, oh, well, now we know how to design a page. Yeah. Well, yeah, that's still a statistical attribution, and it in no way addresses what's the actual information for someone who's got disabilities, who's landed on this electronic thing.
Yeah. You know what else is interesting? As we age, as baby boomers age, as people age, depending on technology, I'm going to be really curious to see how much that tracking goes, because my mom, who's 86, even before COVID, she was, you know, scheduling, doing their medical appointments online. She banked online. She grocery shopped online. I can guarantee you her eyes aren't going where like my 20-year-old daughter's eyes are going. So how relevant is it as we progress? Probably less and less.
Yeah.
All right. Well, are you going to give a webinar? Did I hear you say you've got another webinar coming up in the future that people should know about?
I do. And I don't have the details, but I will put it on the end of this. It's with a group. So in Minnesota and many states have these incubator startups, right? Technology startups. So it's with MinStar. And I think it's available online, and I will send you a link to that and you can send it out. We're going to do a 3-part series, and I'm going to have, the first one will be very similar to this, but then the next 2 coming up in November and December will be more technical, and they will not be taught by me, but they will be taught by a couple of my auditors. And the audience there is geared towards agency people, people who are building websites and that type of thing. So very similar to a lot of the organizations you have there in sunny California.
Great. Well, I think I know several agencies that will want to attend that. So I will get that word out.
Awesome. Thank you so much for that. And again, it was such a pleasure spending time with all of you on this Friday.
Thank you so much for doing this. Both you guys were great. And I know that I'm going to share this content in a video. And so everybody have a fabulous weekend.
Thank you. Take care, everyone.
Thank you both.
Bye.
Thanks. Bye.